Thank you again to Boat Rocker for presenting this session and the In the Room series. With no further ado, I'd like to introduce our panel. First, I'd like to welcome Jamie Goodman, Vice President, Legal and Business Affairs at Boat Rocker Media. Jamie handles an array of development and production legal matters for the studio's various kids and family projects. Welcome, Jamie.
Thanks, Katie. Good to be here.
Next, we have Jeff Young. Jeff is an entertainment media and sports lawyer with 35 years of experience. He is a member of the bars of British Columbia and California and a trademark agent in both Canada and the US. He routinely deals with issues involving fair dealing and clearances. Welcome, Jeff. Next is Lydia Guo, entertainment lawyer at Chandler, Fogden, Aldous Entertainment Law. Prior to this, Lydia held senior executive positions in business and legal affairs at studios, production companies, and streamers. As part of the original series team at Netflix in LA, Lydia negotiated talent, rights, and production deals on a wide range of series around the world, including high-budget series such as Lock and Key. Welcome. Hi, Lydia. And finally, I'd like to welcome our moderator for today's session, Stephanie Herrera. Stephanie is an award-winning actor and writer and an active member of Actor Toronto and the WGC. She also heads the entertainment division at McCam Insurance Brokers, where she regularly speaks at film festivals and film schools on the ABCs of production and E&O insurance. Thank you all so much for joining us here. Welcome.
Thank you so much, Katie. Awesome. We're all set. Thank you. This is a phenomenal opportunity to speak to some incredible lawyers, and your backgrounds are phenomenal. So we've got lots of questions specifically I think we're going to touch all the areas. So I just kind of wanted to start. We have a lot of emerging filmmakers here interested in, and this is probably their first real opportunity to speak to lawyers. And we have sort of this misconception that lawyers, or maybe not misconception, that lawyers are extremely expensive and super busy and not available for the smaller and emerging filmmakers. So what would be some advice? Maybe I'll start with you, Lydia. What would you say is some sort of advice when you're an emerging filmmaker, you have a lot of questions? Where and when would you suggest a filmmaker to seek out an entertainment lawyer? How would they go about that? When in their process do you think it's a good time to start looking for them?
Hi, Stephanie. So I have to agree, entertainment lawyers can be very expensive. I would say that from an entertainment lawyer's point of view, engages as early in the process as possible to try to avoid mistakes down the line. That being said, I do think it would be best for both parties, the busy lawyer and the emerging producer, to be really judicious as to how to use us. I try to tell clients, I will advise on A, B, and C. Maybe I'll help with the business negotiations. We'll wrap up a term sheet, and then we'll hold off on the long form agreement until the economics of the project become a little bit clearer. So, again, we try to be as practical as possible. Nobody wants to surprise a client with a nasty bill. And most importantly, we want our expectations to be in line with each other.
Okay. And so would you say right at the beginning when they start, I also have talked to a few entertainment lawyers that said the earlier the better, because then they can actually help create those documents and those agreements and everything. Like it's almost like templates that they can provide. Is that like right when they're starting to get their film up and running, basically?
Yeah, I must agree. As early as possible. Something that I've had on my hands in the last few months are disputes between one partner and another because there was some handshake arrangement as to how they will collaborate in the future. One partner gets really busy, lets the other one down, and then they're trying to figure out, who is still entitled to what. So yes, if we can all sit down a little bit earlier in the process, as early as possible, to try to figure out what the personnel and the roles look like, what the rights look like, try to do all of that and be really clear as to where you need us and where you probably don't need us at this stage.
Amazing. So Jeff, that's sort of another question as well, in terms of the concept of I can't afford a lawyer. So how would you say that? I mean, I've also seen it in the insurance side of things where people are like, oh, I can't really afford insurance. And my answer is always, can you afford $1 million, $2 million lawsuit? So it's really about budgeting for that. So I know that you had a great story that you told us
Well,
before, that
part of
concept
the
of I can't afford it.
part of the reality is that none of us don't none of us know what we don't know, and what you don't know is the problems you're going to run into if you end up not retaining a lawyer. One of the biggest sort of significant examples of that was a film I worked on where the people that were producing ended up, we discovered, ended up in a dispute where no documents with anybody were signed. Everybody put together a full feature film out of love and hired all their actors, hired all their crew, and incorporated business with each other. And there wasn't a single piece of paper other than the self-incorporation documents that were created. There was a massive dispute. People were really upset for various reasons. What probably could have been done, it's an independent feature film, legal fee of like even a flat fee of like between 50 and 20,000 is not unreasonable for us to have said. And that's another thing. If you're doing everything right and talking to us first, it's not unreasonable for us to discover or discuss a flat fee with the filmmaker to do everything. And uh, it would have saved a lot of money. So let's say we looked at that and said $20,000 plus relevant taxes was going to be our fee, subject to no problems arising. We would have provided templates. We would have helped with clearance. We would have worked with the client and helped them with pretty much everything they need. We have different lawyers in the firm with different billing rates. We could have put it together. It ended up that when they went to court, they actually wound up filing in Supreme Court. Each side spent somewhere around 80,000 before taxes on litigation fees and preparation for litigation. They went through several rounds of discovery, and that did not include going to trial, but it did include trial prep from both sides. You end up with the proverbial courthouse step settlement, and the final result was that they divided various rights and put everything together for cost that for a difference of maybe less than $1,000 of what I felt I could have negotiated with everybody if we were able to handle it. The difference, of course, is not only the $80,000 that each side were out of pocket, they still had to spend about 15,000 for us to backwards paper everything with the settlement, because we have great litigation lawyers, but they're not film lawyers. And of course, we had to use film-based documents like writers' agreements, directors' agreements, actor releases, all the stuff you normally would do. We had to prepare that. And we had to prepare that in a rush of overnight. So we had to have like a team of two lawyers and a legal assistant just stopping everything, doing these documents overnight so they could settle. And
Exactly.
that was, of course, a premium charge because we were all staying up, late trying to type it all. And this was slightly before COVID, so we were in the office working really hard. So yeah, not a pleasant experience for anybody, and there was no need for it.
No, absolutely. And it came exactly like you're saying. And the stress on top of that for everybody across the board could have just,
Oh, including us. We were
yeah.
the film was not being made, and just FYI, it delayed the release of the film. And for all the filmmakers out there who I unfortunately can't see, but if you're watching, you're gonna realize that you do not want to delay potential distribution deals, etc. Because I'm sure everybody here on the panel knows how exciting it is for a distributor to sign a deal with a pending Supreme Court lawsuit.
Yeah, exactly, exactly.
Not
And
a,
we'll get into more of that in terms of, I have some questions about errors and omissions, the E&O insurance and distribution, because I've heard some horror stories too, where a filmmaker gets a distribution deal and then they come to me and they say, hey, I need something called an E&O insurance. And then, they start at $3,000 plus legal fees. And they go, but this was my passion project. I spent all my money, and they've lost distribution deals, and you never want to see that. So we always say budget you know, and lawyer fees, like in every budget should always be there in the case that, and with that intention, because we're all making films to get distributed, always have the intention, I need to reserve that like 10,000 or whatever you're going to budget for your E&O.
I'll add completion bonding to that as a category too.
Oh, there you go. Okay, perfect. Wonderful. So I'm going to get a little specific in my next question. So Jeff, one of the questions that came through is, what compensation is an executive producer typically entitled to? Now, I know that you work as an in-house, more of an in-house. And so so you sort of have this insight into the other side of things, but as a filmmaker coming to the negotiation tables and whatnot, yeah, any advice for these filmmakers? I mean, this is a specific question, if you can answer that as well.
Yeah, I think that was directed to me. I think you mentioned Jeff, but
Yes. Oh,
yeah,
sorry,
so
Jamie. Sorry, Jamie.
that's okay. They both start with J's. Yeah, I mean, it really does depend. There can be quite a range. It depends firstly on the type of executive producer. There's writing executive producers, and then there's non-writing executive producers. In most cases, both of them will be entitled to some fee, be it an episodic royalty, or if it's a feature film, that royalty might be based on a percentage of the production budget. And if they've got good negotiators, they'll probably get some back-end participation as well, some profit participation. It really is quite a range. It's really hard to say without knowing who the person is. The more experienced they are, the more high level, the more credits they have to their name, the higher their fee is probably going to be, and the greater percentage that they're probably going to take. At the outset, though, when you're negotiating these things, it is important to keep in mind who the other parties on the project are going to be. If you give away too much too soon, it might be tough to bring on other producers or other talent. So you want to find the right balance in, you know, satisfying everyone on the project and making sure that no one's getting cut out down the road. So it's hard to be more specific than that, but there is quite a range, and you want to be a little bit careful when you're giving things out.
And so that's the negotiation, not only with the lawyer, but if they're represented by their agent as well. So that's the kind of a negotiating team that you're talking about for people.
That's right.
Excellent. Perfect. Oh, yep. Go ahead, Lydia.
Yes, can I just add that I agree with everything that Jamie said. I would say that when it comes to executive producer fees, especially at an early stage in the process, a lot of people, I think, try to scramble to come up with numbers, and that from a producer point of view can often be a disservice for all the reasons that Jamie pointed, that you might be giving up too much. And something else that I would add is you might be doing a deal which is no longer commensurate with the market at the time that project is actually going into production, especially with streamers like, you know, Netflix, Amazon. The economics of their deals evolve. So you may have precedent, you may have quotes, which are amounts of money that that talent was paid on a previous project, and that may drive a certain range. But I always try to advise on a little bit of flexibility, because, you know, points on the back end, how that's defined, who knows what that's going to be like in 2 years with Disney Plus or Netflix or whomever. And of course, that's a tricky balancing act, because you want to have a degree of concreteness in a deal, but you also don't want to put yourself in a position where you may have to renegotiate. The buyer down the line makes you renegotiate, and you may not have that much leverage at that point.
Interesting.
And you also want to save money for the production itself, for the actual budget and the crew and everything else. Yeah.
Thank you. Absolutely.
But
and Lydia,
my final comment, this is important. Do not forget, until you get 100% of all money that you need in your hands, i.e. in the bank account, don't forget that new money will always come with some credit obligation. That's really important.
Okay, excellent. Perfect. And actually, speaking of credits, one of the questions came in is, and Jeff, because you're in British Columbia, correct? You're
yeah.
So then somebody,
at least for my Canadian practice. I'm
there you go.
for my American.
So yeah, so there was a question here that can one use a home province entertainment lawyer for out of province projects? So, and vice versa, if somebody is working with you, but then they're shooting in Ontario. I know tax credits kind of come in there, but have you seen people bouncing around for the
I think that there's a real concern if you're advising for law that are contracts under the law of British Columbia, if you're not fully licensed in British Columbia. I mean, it's very easy, like for anyone who's checking, you could just literally go to, say, for example, the BC Law Society website, type in the name of your lawyer and double check that they're in good standing, they're insured, the license, it's public information. If not, there's a real risk that if there is not, you know, an understanding of the way the law works in that jurisdiction, your insurance may not cover it. For example, I'm careful enough that with my American practice, I do it all through that firm. I use that firm's signature. And basically, it's mentioned that I'm a member of the BC Bar, but I do it all through my California firm, and vice versa. And it does matter, especially for tax credits, because my BC clients will not be able to get the best tax credit for the services I bill them unless I do it through BC, licensed in BC, and resident in BC.
Perfect. Jamie, you had a comment that you wanted to.
Sorry, that was an accidental click
Oh,
of the
no
hand.
problem.
I think Jeff's answer was very well informed.
Excellent. Lydia, I wanted to ask, because another question came out about streaming. They asked, how has the onset of streaming changed IP production clauses? And because you have that relationship with Netflix and specifically, how can you sort of suggest some things that we should take in consideration as filmmakers with streaming, and have there been any changes? I mean, that was the change, the IP protection clauses. Does that sound?
To be honest, I'm not quite sure what that question was getting at. Was the question about IP protection, like copyright and whatnot? Okay, it wasn't just about
and creative control in general. Because streaming is such a new thing to us.
No.
How does a filmmaker, you know, if they're approaching Netflix and the other streaming services, how can they really take care of that copyright, creative control, IP protection?
Right. And again, I have to preface this by saying this is how the market is right now, or, you know, based on deals that happened this year. I'm not sure what it will look like next year or the year after, but I will say typically when you're going to a streamer like an Amazon or a Netflix, and specifically in the case of a TV project, you want them on board to help develop the project. You know, you're going to be compensated, you're going to have all of your costs recouped. What they ask in return for all of that is a high degree of control. So it's always that sort of perennial business question that any producer as a business person has to ask. You know, how much of my money am I willing to put on the table at risk to try to develop and own and control my IP versus how much am I willing to concede to a party like Netflix at an early stage so that I don't have to pay for a spec script, which could run 100,000, 150,000, you know, out of my own bank account. So I guess to answer the question about streamers, if you want to partner with them at an early stage, you do have to have a pretty honest conversation with yourself and frankly, your advisors, your lawyer, your producing partners. Am I willing to give up a high degree of control? Am I willing to have Netflix take over the project, own the IP, control it from season 1 onwards? But that being said, I don't have to put as much money up front, and I don't have to worry about cobbling together my own distribution deals and financing the project on my own. I'm curious what Jamie's experiences have been.
Yeah, and you know,
recently, but I
like,
know it's a tough nut to crack if you want to both control everything and also work with big streamers.
Exactly.
Yeah,
it's Jamie, this question, I think you might have seen it too, that kind of adds to this too, asking what should writers do to protect the concept of scripts if these projects are still in development and writers have to pitch? They were asking, as far as they know, it's not common for writers to be able to sign an NDA before pitching, correct?
A lot of studios will prefer that the writers sign the studio's own release form, which basically absolves the studio of liability in the event that the studio is already working on something similar. I feel like there is a bit of a misconception though. In my experience, I've never seen a studio or a production company that's on the hunt to steal IP or to take something without purchasing it or crediting it. It's actually, we're generally like overly careful to avoid doing that because we don't want the legal trouble. So I'm not suggesting that writers should just, you know, throw their projects into the ether without being careful about who they're sharing it with. But generally there is some level of good faith that a studio, if they take a pitch, they're not going to do anything with that unless they negotiate the rights to do so. So writers can generally be somewhat at ease, although obviously there's probably some horror stories out there, which I'm guessing Jeff might have one right now.
Yeah, go ahead, Jeff. You wanted to add
No,
something?
it's less horror stories. Is to tell them, our viewers, that at least under American law, and most of us have dreams of the big American something, right? Feature, whatever. I don't know, create a new Marvel hero that they like, whatever. But there is some really good American case law with submissions that were tracked that went to big studios in America. And yes, they're more litigious down there, etc. But there is some really good case law where there's follow through, and the worry that many of our clients or potential clients have is actually balanced by some really good case law in favor of the submittors.
And I would also add, I mean, if people are nervous, you can submit before you give a full pitch, just a top line 2 or 3 sentence synopsis. And if the studio is responsible and good, if they have other projects that look like that already, they'll say, we don't want to hear this pitch because we're already working on something similar. So that's one way to at least get a little bit of certainty that they're not just going to hear your whole thing and run with it without you.
Interesting. Okay. And then Jamie, just a follow-up question. When does someone need to have a chain of title? And do they need to copyright their script before they start pitching it out?
So this is actually similar to Lydia's answer earlier about when to engage counsel. The sooner the better. They don't need to do anything to register copyright in the script right away. You'll own copyright in whatever you write. Registering the script with the Copyright Office is an extra protection that you can probably put off until the project is a little more realized. When it comes to chain of title, though, it's also something that you don't need to paper on the first day, but the sooner you do it, the better. Eventually, you're going to get the thing produced and you're going to want to sell it. And whoever you sell it to is going to ask for proof of chain of title. So to go backwards in time and have to piece it together down the road is a lot harder than just getting it papered from the outset. So the sooner the better, basically.
Excellent.
Just the Canadian copyright system is a little flawed, frankly. If you go to the CIPO, Canadian Intellectual Property Office, you'll see that you can self-register copyright, but unlike the American system, you get to register only a form with the title of the work. You're not permitted to register the actual work, and yet the title, which is the only part you file under copyright law, has no copyright protection. So the one thing you file is not protected, and that's the Canadian system. And for that, you get the lovely privilege of paying the Canadian government, I think is $50 now, maybe 30. It used to be 35, but I don't do them anymore. We let other staff do that because it's too basic. I see a question: should Canadians copyright in the US? To the extent you can and that you care, my recommendation is always to register in the US registry if you can. I had a case that involved not scripts, but the same thing about copyright. And my client wisely, for a music album, registered the actual work in the U.S. Library of Congress system. And it came up that her ex-producer, literally, the classic case of stealing the tracks and using them and putting new words and blah, blah, blah. And she had her filing ready. She had the actual work. The lawyer on the other side said, let's agree on a music producer that we both feel is impartial. And if that producer listens to the tracks and just says, yes, they're the same, we will proceed right to settlement because I don't want to litigate. And that happened. We agreed on a producer. Luckily, that's one of my side things is I also compose and produce, so I knew them, and we pointed a guy in Seattle. I knew the producer was going to sign off. We won that one handily, and we immediately talked about compensation, cease and desist, bypassed the entire trial completely. And it was because my Canadian client was wise enough to have done the U.S. filing where the work was deposited.
Interesting. Amazing. So I'm going to go switch over the gears over to life rights, because this comes up a lot with questions with insurance as well. Lydia, can you let us know if one of these questions is, if a person is a public figure, do you need to acquire life rights to include them in a scripted project? And what if they're deceased? So that's a public figure.
So this is a very tricky issue. For most of my clients, I try to tell them, you don't need life rights until you really need life rights. As a generality, the more public the person, the less important it is to get life rights. So in other words, if you can cobble together details of that person's life through public information, Google, whatnot, you can use that information in your scripted project. An example that comes to mind, because I had done a ton of these MOWs, you have like the Harry and Meghan story on A&E in whatever iteration, like every other year. There's always some Harry and Meghan project on air. Those projects almost invariably did not seek life rights from Harry and Meghan. That's because their story, tidbits about their life, those details are so readily available. Of course, that's an extreme example. Most people are not dealing with people who have that level of profile. But as a generality, the more public the person, the less important it is to get a life rights deal in place. That being said, you can't make a story, a film about Harry and Meghan and say whatever it is that you want about them. That will trigger issues like defamation. So you do, again, need to work with a lawyer to make sure that from a script point of view, all the way until the final film is cut, you're not accidentally wading into issues like, disparagement, defamation, all of those things. But that's just a very general answer, to kind of kick off this topic.
Okay. And then just, did anyone else want to add a comment to that particular question? No? Okay, to add to it. The other thing too was talking about a film, the subject of a film provides me with personal photos and videos. Do I pay them for it? If yes, how much? And that's come up a lot too. Like, have you gotten the agreements? I wasn't, is that typical that if they're giving you more information for your project, that you would compensate them for the photos and videos? Or does that usually go off on your sign-offs on your agreements? Maybe, has anyone had any dealings with?
I think it would depend. I think you would want to negotiate that beforehand if you've got an individual on board a project and they've agreed to let you use their life rights or their personality rights. You would expect that would entail things like pictures and videos. The fee aside, what's most important is that you want to just have the proper release and permission from them to include it. So if it's not covered in the initial deal that you struck with them, and then they say, here's some extra pictures I found, you might want to just double check to make sure that you actually have some paper trail that says that you can use those in your production.
Got it. Jeff, was that a hand?
Yeah, I sorry.
Yeah.
The photos are unique because you have two layers of rights that are completely different to govern them. You have copyright in the photo, which often is still in the hands of the photographer, not the subjects. And then you have rights of publicity and privacy of the subjects in the photo, which is often governed usually in America by the state law or in Canada by the provincial laws, because rights of publicity and privacy are not governed by copyright. So you've got exclusive federal jurisdiction over copyright, governing copyright in the photo, i.e. the photographer, and then you've got the people in the photo, which are governed by usually state or provincial rights of publicity and privacy. You've got to clear both levels with the right person. Somebody who says, I'm in the photo, I own all of it, has forgotten that there's copyright in the photograph.
Excellent. Perfect. Just another question just popped up in our chat here. How much do you charge for a legal opinion on chain of title?
Is that I'll throw that over to maybe Lydia. You do as much as that as me, probably.
It really depends. I would say generally we try to be very practical about legal fees. If a project is a micro budget project, something less than $1 million, that entails one set of fees. If we're looking at a more commercial, like Hallmark, MOW, there's sort of a general set of fees that most entertainment lawyers would charge. To be honest, I've never been asked specifically to just do one piece. Usually as production counsel, you do the whole thing. And again, if you are just looking for that specific piece, always be upfront about the budget of the project, how commercial it is, and most lawyers will be very reasonable in giving you a range.
Okay, excellent. Jeff, we chatted just off screen before we started about fair dealing and fair use, which often confuses people. Can you give us just a quick definition of the difference between fair
Sure.
dealing and fair use?
My first comment on this is a mug that I plan to have here, but it's in the dishwasher somewhere, which says, "Please don't confuse your Google search with my law degree." And I speak that in a sincere way, because I can't tell you how often clients try to figure all this out on their own, and they make it worse than if they just asked. Canada has no law of fair use. If you read something that says fair use will cover this, it's not Canadian. And so if you're making a Canadian project with a Canadian lawyer, with a Canadian insurer, please don't think that we can give any opinion based on fair use. Most Canadian lawyers don't try to become an expert. Why would they? And most of them wouldn't want to go through what I did to pass the California bar anyway. And fair use is not even talked about in the California bar. It is an entirely American concept under American law. And even with my entertainment exclusive colleagues that work with me in the States at that firm right in LA, we hand out complex fair use doctrines to a firm that does nothing but opine on fair use. Fair dealing is much more limited in terms of what it covers. And one great example is fair use is a overriding doctrine that covers the use, which means if you do a certain thing, like I recently did, where we made a document, or my clients made a documentary about the Toronto rock and roll festival of 1969 that John Lennon appeared for the first time with the Plastic Ono band. Super fascinating show, but crazy, scary clearances. We actually managed to get an American opinion under fair use that said we could use the music clips with the video up to a certain amount of time without getting separate releases from the owners, the publishers of those songs. And we're talking songs by Chuck Berry, the Beatles, Gene Vincent, legendary songs that will attract lawsuits in 15 seconds if we don't do it right. I was scared to give that on my own, so I was working with the American firm. There's ways to deal with that. On the other hand, I did all the Canadian clearances. I had to run away from fair use and only rely on fair dealing. Why? Here's an example. If you say something about something and you do a parody under the Canadian Copyright Act, you're allowed to do parodies without it infringing on copyright. But that's it. That's the only piece of legislation on parody. So if you parody, you could still be infringing on trademarks, rights of publicity and privacy, all these defamation. None of those things are exempt. Whereas under fair use, the American doctrine, you get coverage for all of that, and you get way more room to do your thing. So usually if we're getting into parodies or we're using content, you can't do it under Canadian law. What happened in our American situations, we did a workaround where the E&O was obtained through our American distributors, and that made it so that there was jurisdiction, and then we were able to make the project partially under fair use and get an opinion from the American lawyers, thus allowing the American insurers to insure it worldwide under fair use. So there's a lot of working around, which Stephanie, if you're in the insurance business, you can see how much work we put into even planning that and making sure I did the Canadian opinion and my American colleagues did the American opinion, but then I was able to rely on their opinion to me as a California lawyer to clear both sides of the fence.
Interesting. Jamie, I had a question here that I'm going to start with you, and probably everyone's might have an opinion on this one. It was a specific question, but it's kind of a broad thing to get your perspective on both the in-house side of things as well as the talent. The question was, as an actor or stunt person, should I look into incorporating or sole proprietorship? What's sort of ideal when approaching a studio? Like, what do they like to see? Would they rather work with an incorporated? I know personally, it gives a level of protection for people in terms as an insurance broker speaking, it gives you a level of protection. However, when I was looking into incorporating, you have to also understand that money is now the incorporation's money. You are now an employee, and that means there's going to be incorporation taxes that you have to deal with. So there is a level that a lot of people are like, oh, I'll just incorporate, no problem. Now I can save myself on taxes and things like that. However, which you should definitely talk to an accountant about. But in terms of dealing with, like, would a studio prefer to deal with an incorporated company versus an individual?
To be honest, my answer is probably a little too simple for this. We don't really have a preference. If it's the right person for the job, and they want to incorporate, and they want to contract as an individual or through their loan out company, we're not going to pass up on them because they have a less favorable contracting entity than might be easier. We'll make it work with whoever the person is, and however they want to, go about getting their money and handling their taxes. That's totally up to them. I think Lydia might have some better guidance for the on the talent side.
Yeah, Lydia, I mean, did you suggest to people to incorporate when it comes to
I mean, I again echo what Jamie says. From a studio production company streamer point of view, no one really minds. You can be engaged personally or through your loan out. I think this is primarily an accounting concern. You should speak to your accountant to figure out what makes the most sense for you in terms of your personal finances. We all know that if you go through a corp, you have to pay an initial fee and then a yearly fee. So at what point in your compensation level and how much you need to live on do those fees make sense? In other words, I don't really push people to do it at like any specific stage. Obviously, if they're a producer and they're trying to build an IP library and setting up many projects in development, I would encourage them to consider incorporating, having the company own the rights. But until you get to that point, I do think this is primarily an accounting question.
Okay.
I will say the one area you have to watch out for is if you're below the line. The loan out corporation has caused problems at the workers' compensation stage with WorkSafe. There was a case that was litigated involving Gabriel Carteris, actually the actor that was one of the leads in the original Beverly Hills 90210. She's now the president of the SAG-AFTRA in the States. She was in a BC production. She got injured with a scene with an over-aggressive co-actor in some mystery movie where there was supposed to be a choking scene. Her allegations are that she was injured in the scene. She didn't want to be covered by WorkSafe because she would get more out of going after the general commercial liability insurance by the production company. So that's commercial general liability is CGL as opposed to E&O. That's your area of specialty, Stephanie, so I won't step on that. But the workers, the labor appeal board, I believe, whatever the appeal body is, actually ruled and said, yes, because you're a loan out company, this is outside the workers' compensation scheme, and that created all sorts of problems. And there was a while where productions were not happy about using loan out corps. And finally, the latest permutation we're seeing in productions is if you want to go through a loan out corp, you not only have to buy your own WorkSafe, but you must get the WorkSafe or you're in breach of contract. I was directly involved with that case. We actually had meetings at WorkSafe when I was the chief negotiator at UBCP, and it was a really big deal for a while. And then the industry sort of adjusted to it. So if you're going to go being a loan out corporation and you're below the line, be aware that that is a real thing you have to deal with.
Okay. And below the line for people to know when you say below the line.
Well, a crew and people who are not, say, for example, lead cast or a director or somebody who is in one of the roles where you negotiate those issues. And that would be apparent in the contract that we prepare, whether
Okay.
you're going through a loan out corporation or not.
Gotcha. There was one question. Oh, when one disappeared on me, they're kind of similar to what we were talking about. One person said that they wanted to recreate something with David Bowie, which I think fits in that area of when they're a celebrity and whatnot. So I think that was answered. There's another one. There's a subject who's the base of a screenplay I'm writing. Except for a few news articles, there's not much info on her. I will be fictionalizing this character, possibly putting her into another professional milieu. Would I need to get her okay on this? So what happens when we get to the point where you're taking someone, you're changing names, fictionalizing, but there's still that element of it based on true events. So I guess maybe we can put it in that kind of a category. Lydia, did you want to speak to that question about based on true events? Like how much play do we have there?
Sure. I would say when I first read this question, I thought perhaps this would be one of those inspired by true events, which, from an insurance point of view, as you know, Stephanie, is sort of a lower threshold. This is a scripted project. You're fictionalizing the character. I assume you're using a different name, different profession. You're not trying to identify the character as that individual. Without knowing the details of how you're planning to portray this person, if you're deviating from any known facts, I would say this is probably a lower risk project. That being said, one piece of advice that I often give clients when it comes to life rights is not so much do you need life rights, but rather could you benefit from it, primarily from a publicity point of view. You don't want to go down the path of doing an inspired by project and having someone come out and say, hey, I'm really not cool with this project. I don't like how this was portrayed. And, as they say, sometimes all publicity is good publicity, but sometimes it's not. So if you can get that person on board at an earlier stage through a life rights deal, try to encourage them to support the project openly, publicly, but at least not oppose the project, that could be a real asset to you. So, again, you have to manage expectations. You don't want to set up a life rights deal in a way where that individual thinks that suddenly they have creative control over it. But at the same time, I don't think you want to be in a position where you're clearly doing a story inspired by someone, and then they come out and say, this was so not cool. We all know recent projects that have had that kind of controversy.
Okay, perfect.
That being said, I just will say the difference between doing a project like that, relying on fair dealing in Canada versus fair use, is that's where there's like a chasm. It's gigantic. You could get away with so much more under American fair use than you possibly can with Canadian fair dealing. So if you have a co-producer that can connect to America where you can claim American fair use jurisdiction and get insured for E&O down there on a worldwide basis, that's that a lot of projects have from my clients have moved down stateside because of precisely that, where there's no way you're going to get permission. You're doing a documentary for a political cause against Donald Trump, and so there's no point in even making the phone call. It's not going to happen. But because of the fair use rules down in America, go for it. Like you can get away with it. Political figures, all that stuff.
Interesting. Jamie, because you're working sort of in the kids animation space with Guru and Wild Brain and that kind of stuff, you probably see a lot of times where there's an adaptation to books, comics, graphic novels, like something that might be a different literary IP that's going to be turned into something. So one of the questions that came in is, what is the biggest legal obstacle when representing a literary IP to screen adaptation, whether it's a book, graphic novel?
Yeah, I mean, this is, I don't think this is particular to animation.
Not at all, but yeah,
There's
I'd probably say a lot.
there's two things that come to mind, or maybe three. I mean, the first is just the bundle of rights that you get at the outset when you're negotiating the option and purchase with the author or their publishing company. You want to make sure that you, as the producer, that you can do everything that you want to do with that property. So you might get the rights to produce a TV show adaptation or a film adaptation, but you want to make sure that you can also sell merchandise based on it, that you can exploit it overseas, that you can make different language remakes of it. So you want to cast as wide a net as possible. There's other things that can get tricky, I suppose, when it comes to what the original author wants to retain. So I've seen some tricky situations where a studio will acquire the rights to make an adaptation of something, but the author retains the rights to make a sequel to that, that story or that graphic novel. And then you've got two different works out in the market. You've got like the official TV show, and then you've got this sequel. There's a popular show called Game of Thrones where I know they had all the rights to that, I'm sure HBO, but there's apparently a different ending coming in the book than was on the screen. And I think you want to avoid situations where the audience gets two different stories. So there's a lot of different considerations that can go into it. I'd say the biggest challenge, though, is that one about sequels aside, that's sort of an interesting one, I find. But the biggest hurdle would be to just make sure that you can do everything you want to do with the property from the outset.
Interesting. Absolutely. What I want to kind of go back to the insurance side of things, because this comes up time and time again with heirs and omissions. They're looking for distribute, or they have, distribution, a deal is on the table with their short film for these filmmakers. And then and then one of the questions I ask, because I can quotes are free to get insurance, but the big question is that insurance company has is, who's your lawyer? What law firm? We need a clearance, a title clearance, and a letter, a clearance report, basically from the lawyer. I've never seen one personally, because I usually that's all gets passed off to the insurance company. So what is in a clearance report? I would love to get, how many of you have actually sat down and done a title report, clearance report? Because there are title and clearance houses. A lot of insurance companies don't like those. So what goes into those?
So,
yeah, Jamie?
At a studio, I mean, we'll do these for every production. We want to be careful, and as you mentioned, the insurer requires it. So it's usually a two-stage thing where we'll go to an outside research house, and there's a few really good ones in Canada that we've used, and they'll do a deep dive through a deep dive internet search, a deep dive trademark search. They'll go into their own databases and search things that the average person wouldn't really be able to find, including the average lawyer. So they combine all those results. They'll send it to us, sometimes with a recommendation, sometimes not. And then it's up to the studio's lawyer or the project's lawyer to make a determination if what's in the report is scary or risky enough to not proceed. And often, that's, through those levels, you tend to weed out anything that might be infringing, hopefully, so that by the time you decide on a title or a character or the story itself, by the time it gets produced, you should have eliminated all those risky things. Obviously, in reality, things fall through the cracks sometimes, and that's why you still get insurance, and that's why lawyers still have to deal with lawsuits. But the more you can do to eliminate those risks, the better. And research script reports, title reports are really helpful tools to do that.
Now, I've been told that there can be, in terms of title, there can be an exclusion put in the insurance policy for title, but really it was more about documentaries, that because typically documentaries have titles that have very unique, and you can put exclusions in there. Would you, as legal representatives, if people are looking to sort of bring down that premium, put in exclusions, try to get through, do you ever kind of go in that vein of exclusions, or is more of the advice of try to get everything, guys? I mean, I know it's more expensive, but get all those T's crossed and I's dotted. Or have you worked with your clients in terms of getting some exclusions to help bring down premiums?
I would say I'm actually Research House's legal counsel, so I've been around the clearance thing from when they first incorporated and set up, and I'm actually on their website, it seems like still. So we deal with this all the time. My practice, I guess, style is that if we're in on the ground floor, we can usually get everything cleared the right way, because a lot of it has to do with what's in the release. You'll get the insurance the insurance companies, underwriters, lawyers saying, we just want moral rights cleared, and that's in the clearance instructions. If you've got the wrong release and people have signed, it's really hard to get them to sign again. But if they see it the first time, usually they're getting interviewed and they're good with it. And so the exclusions tend to happen when the clients barrel ahead and do their own thing. And one of my worst sort of things that happens that I see is people download the release forms from the internet, not looking at what jurisdiction, and then all of a sudden that's what's signed, and it's really brutal to go back and get people to sign. I do have a humorous story for that. It's kind of fun. Which is that we recently worked on a science-based documentary, and this sort of happened with a few people, and one of the people that originally signed was Neil deGrasse Tyson, who we thought, oh no, how are we going to get this really famous guy to re-sign? He turned out to be like wonderful, except that with my release, he decided that, I'm only going to give you the world, I'm not giving you the universe, because scientifically I can't do that. So I've now got a souvenir release with Neil deGrasse Tyson crossing out universe, writing in world, initialing it, and now I've got an autograph. That's kind of a fun story.
Oh,
And
that's
of course
awesome.
I would say would accept it, but yes, you don't want like the other version of somebody that famous going, I signed once, I'll never sign again, and now we get into exclusions.
Absolutely. Great. And it is interesting that you bring that up, the whole concept of the universe. Why is that in there? Can anyone tell?
There is a story, which is
Okay.
apparently that in one of the space shuttle launches, I believe it was Universal Music, wanted to do PR and package like playlists for the astronauts, because that would be a fun thing to do. And of course, the internet isn't up there. So they thought this was a good publicity move. And all the writers and the writers organization looked at their publishing contracts and went, we gave you the world. We didn't give you the universe. We want extra money if you're going to put our music in the space shuttle. That's
Wow.
apparently the story.
That's the story. Awesome. I'm also going to invite all of our panelists to, if you feel comfortable and you'd like to put your contact information in the chat so that everyone has access to, if you're open to any questions, or if people are looking for legal representation and you're open for help, definitely put that in. I'm going to put my contact information in the chat as well. If anyone would like some information about insurance, getting quotes, as I mentioned, quotes are always free, but you definitely need a lawyer. So you'll definitely start shopping around. Any advice in terms of, I'm kind of going around the room, about finding a lawyer? Is it a matter of just, Googling, calling them and starting that conversation? Because I think the main question that a lot of these filmmakers are going to say is, how much do you charge to clear my film? I've got a distribution. How is the best way to approach you so that no one's wasting your time, that you can sort of, or are there suggestions in terms of these indie filmmakers to find someone? Jamie, can I start with you in terms of your advice on finding a lawyer? How do we find a lawyer?
Yeah, I mean, I think it is useful to shop around a little bit. I don't think you should necessarily go to the first person you speak to, because every lawyer is going to be able to offer you something, but you want to find someone who can really tailor their services to the kind of project that you're making and to the types of funds that you have available. So I don't know that that's super helpful in terms of how to go about it. I would just say that it's worth the time to look around a little bit. Usually asking for referrals and recommendations is probably the best way to get some trust in who you're talking to. Excellent.
Lydia, do you have any other suggestions or things that you would like to have someone approach you?
The only thing I would add is that you do need to make sure it's a good fit. Oftentimes, you may be certain that this person can do the job, which they probably can, but is that the person whose call you will take at 6 o'clock on a Friday telling you, this is not a good idea, you really should rethink this? because at the end of the day, we are paid to give advice, and oftentimes it's not advice that you may want to hear. The number of times I have to tell someone like, look, I'm just going to have to say this plainly, but, this offer for this deal, it's just not realistic. If you want to be serious about the deal, this is what it has to look like. Not everyone wants to work that way. Not everyone wants to have that cold dose of reality. So, find someone who can work with you and your working style.
Okay, wonderful. Jeff, do you have any advice in terms of finding a lawyer? And
I would say the one thing we've talked a lot about is errors and omissions insurance. There are insurance companies that will only accept certain lawyers that are on their list, and if you aren't one of them, that does cause a problem. That's why you get the question in the application: who's your lawyer? Have they had any claims? How many years experience in entertainment? And so for E&O specifically, you do have to have somebody that fits, or else they clear it, and the insurance company won't accept it.
true, absolutely. And again, to everybody, getting a lawyer on your side well in advance, as we were talking about, as early, like Jamie was mentioning, as early as possible, because then again, if you have a locked film and then you're getting your clearance reports and I've had a case of that. Somebody, they had to change the title of the movie, this is a locked film that had already been screening at film festivals.
Oh yeah, that's minor.
Yeah.
I had one where they had to change what we had to really jump through hoops, but in effect it was looking like the lead character's name was going to have to change, and they shot the film. Hadn't gone to post, but wow, we found a way around it. But
oh, thank God. Could you imagine that?
I see that way too often, sadly.
There's a couple of last questions here. This is a great one. What advice would you give to someone considering becoming an entertainment lawyer? Jamie, can we start with you? Any advice on taking your path?
Yeah, that's a good question. One I often reflect on myself. I think know the reasons that you want to go into it, and if there is an area that you're particularly interested in, I think it's worth pursuing. I think a lot of entertainment lawyers are artists themselves or want to be artists, and that's what led them to this field in the first place. So if you have that passion already, try to pursue entertainment law in that area, because it'll make it a lot more interesting and exciting to work on the projects that you're already interested in.
Mm-hmm. Lydia, if you could do it all over again, would you do anything different to get to this path of entertainment law?
Honestly, what I would tell someone, maybe 10 years, 15 years younger than me is it's not all that glamorous. At the end of the day, the work can feel like grunt work, like any other job. So like Jamie says, know your why, know why you're in this business, whether you're a writer, composer yourself, or in my case, I came through it sort of in a circuitous way through the business side, working primarily in business affairs first in my career, understanding what drives you, is it the deal making? Is it the E&O legal side? And really focusing on that.
Excellent. Jeff, did you want to add anything to that?
I'm really not the best person to ask, because I'm turning 60 in a few months and I'm constantly talking about retiring. So it's been for me, it's reflecting back, saying there's a lot of wonderful things that the money is not bad, I'm going to be honest. And so one of the things, as a guy whose primary drive in life is to create music, is that my grand piano was paid for through my law career, so that part's good. But honestly, it is the one thing that's correct is if you want the glamour of the entertainment industry, it doesn't come from being a lawyer. Seriously, be somebody on screen, or be somebody who is the director. Do your creative thing. That's the one thing I would say. Don't look at law as a way of sort of being around the creative stuff. If you want to be in the creative stuff, do it. Like really do that. So when I want to be creative, I do the music. I don't do law to pretend to get close to the music. If I'm willing to do law, I'm a lawyer. I don't do the creative stuff. I'm here to make the business deal work.
Wonderful. I'm just going to grab this last question before we close up. Jamie, can I throw this one to you? Are lawyers helpful when sending out pitch decks? Do you, in terms of, is that necessary?
As in, like, should they have a lawyer before they send out their pitch decks?
Yeah.
I think it never hurts. I don't know that there's that much more work that's, I mean, at that point, it's mostly creative, but if, for example, the studio is going to ask you to sign a release form when you send your pitch deck to someone, you might want to have a lawyer take a look at that to make sure you're not giving up too many rights or remedies before they've even looked at your project. So I think it never hurts.
Absolutely. Fantastic. I'm going to bring Katie back, but I first want to thank you all so much, Jeff, Jamie, and Lydia, for this wonderful discussion. I'll turn it over to you, Katie, and all the contact information's in the chat box, and we hope that we're going to hear from all of you.
Thank you, Stephanie.
Thanks, everyone. Thanks.
Thanks.
Bye.
Thank you so much, everyone. I just wanted to echo what Stephanie said. A huge thank you to Jamie, Jeff, and Lydia for joining us on the session today, and Stephanie for leading us through all of those questions. That was so great. Thank you so much for sharing all of your expertise and advice, and to all of you for sending in your questions in advance. I hope that this was helpful to you in sort of starting out your relationship with an entertainment lawyer. Another thank you as well to our partners at Boat Rocker for presenting this session.